If you have a pending asylum case, or you're waiting on a green card, stop what you're doing and watch this right now. The Department of Homeland Security has just lifted its hold on hundreds of thousands of asylum cases. But, and this is a big but, not everyone is included. 2 federal courts have also ruled that many immigrants can be detained with no bond. And the April 2026 Visa Bulletin just dropped with some major date movements. This affects you, your family, or someone you know. Let's break it all down. Welcome back to Immigration Radar USA, your trusted source for clear, accurate, and up-to-date immigration news. Today we have a big show covering 3 major immigration developments happening right now in March 2026. Everything you're about to hear is based on official sources, including USCIS policy statements, official court rulings from the 5th and 8th Circuit Courts of Appeals, and the April 2026 Visa Bulletin released by the U.S. Department of State. We are going to cover, number 1, DHS has lifted its asylum adjudication hold, but only for some people. Number 2, federal courts say the government can detain immigrants without bond. And number 3, the April 2026 Visa Bulletin is out, and there is good news for certain green card applicants. Let's start with the biggest story first. Okay, let's go back to December 2025. The Trump administration ordered USCIS, that's U.S. Citizenship and Immigration Services, to put a complete hold on all asylum applications. We're talking about roughly 1.5 million pending asylum cases. Everything froze. No interviews, no decisions, nothing. This happened because of a national security concern after a deadly attack. The government said it needed to conduct thorough security screening of all asylum applicants before moving forward. That hold lasted for months. Hundreds of thousands of people were stuck, unable to get decisions on their cases, unable to move forward with their lives. But here is the latest update, and this just came in. USCIS has now lifted that hold, but only for asylum seekers from countries that are not on the high-risk travel ban list. This is what USCIS officially said, and I'm quoting their statement directly. On-screen text, official USCIS statement. USCIS has lifted the adjudicative hold for thoroughly screened asylum seekers from non-high-risk countries. This move allows resources to focus on continued rigorous national security and public safety vetting for higher-risk cases. So what does that mean in plain English? If you are from a country that is not on the travel ban list, and if you have already been thoroughly screened, USCIS will now start processing your asylum case again. But if you are from one of the 39 countries currently listed on President Trump's travel ban, your case remains frozen. Those countries include nations in Africa, like Nigeria, Senegal, Somalia, and Zimbabwe, as well as countries in Asia like Afghanistan, Iran, and Laos, and in Latin America, including Cuba, Haiti, and Venezuela. So the key question is your country on the travel ban list? If your country is not on that list, this is potentially very good news for you. Processing may resume soon. If your country is on that list, the hold continues. You are still in a waiting period with no clear end date. One more important thing to know, this change only affects affirmative asylum cases, meaning cases filed directly with USCIS. If your asylum case is an immigration court that is called a defensive asylum case, it is handled by an immigration judge and is not directly affected by this USCIS hold change. If you are unsure which category you fall into, please speak with a licensed immigration attorney. Now let's talk about the second major update, and this one is very serious for immigrants who are in detention or who fear being picked up by ICE. 2 major federal appeals courts have now ruled, in separate decisions, that the U.S. government can detain immigrants without offering them a bond hearing. Let me explain both rulings. Ruling number 1. The 5th Circuit Court of Appeals in a case called Buenrostro-Mendez v. Bondi decided on February 6, 2026. The 5th Circuit ruled 2-1 that certain immigrants, specifically those classified as applicants for admission under the law, can be held in mandatory detention with no right to a bond hearing. The court said that under a section of immigration law, anyone who entered the U.S. without authorization and has not been formally admitted is considered to be seeking admission, and people who are seeking admission can be detained without bond. Now, this is a dramatic ruling. In fact, the dissenting judge in this case noted that over 350 district court judges across the country had previously ruled against the government on this very issue. Only 6 had ruled in favor. Yet the Fifth Circuit went the other way. This ruling currently applies within the Fifth Circuit that covers the states of Texas, Louisiana, and Mississippi. Ruling number 2, the Eighth Circuit Court of Appeals just last week, on March 26, 2026, the Eighth Circuit issued a similar ruling in the case of Avila versus Bondi. In a 2-to-1 decision, they said the law is clear. Immigrants who are classified as applicants for admission can be detained without bond. The Eighth Circuit covers 7 states: Minnesota, Iowa, Missouri, Arkansas, Nebraska, North Dakota, and South Dakota. So now we have 2 major federal appeals courts, covering a large portion of the country, saying no bond for certain categories of detained immigrants. What does this mean for you? If you are in immigration detention in Texas, Louisiana, Mississippi, or any of the Eighth Circuit states, your ability to request a bond hearing may now be extremely limited or completely blocked. If you were arrested by Border Patrol after crossing the border without permission, even if you were later released, you may now be considered an applicant for admission under this new interpretation. That makes you potentially subject to mandatory detention with no bond if picked up again. For those of you outside these circuits, in states like California, New York, or Illinois, these rulings do not automatically apply. But legal advocates are warning that the government may try to apply this interpretation nationwide. The ACLU and other immigration legal organizations say they are reviewing these decisions and considering next steps. The bottom line: if you or a loved one is detained by ICE right now, contact an immigration attorney immediately. Do not wait. Your access to a bond hearing may depend on where you are and the specific facts of your case. All right, let's move on to something a little more positive for many of you watching. The U.S. Department of State released the April 2026 Visa Bulletin on March 27th, and there is some real forward movement in several employment-based categories. Let me break this down simply. The Visa Bulletin is a monthly update that tells green card applicants when they can file their paperwork based on their priority date. That is the date when their original petition was filed. There are 2 important charts. 1, the final action dates chart. This is the date when your green card can actually be approved and issued. 2, the dates for filing chart. This is the earlier date when you can submit your adjustment of status application to USCIS, even if your green card isn't ready yet. USCIS has confirmed that for April 2026, employment-based applicants can use the dates for filing chart, which means you may be able to file sooner. Now, let's look at the key movements. EB, 1 category, priority workers. For most countries, EB 1 remains current. That means you can file right now, regardless of your priority date. For China and India, the final action date advances to April 1st, 2023. That is meaningful movement for Indian and Chinese EB 1 applicants. EB 2 category, advanced degree professionals. For most countries other than India and China, EB 2 is now current on both charts. For India, the dates for filing advances to January 15th, 2015. That is a gain of about 2.5 months from last time. Good news for India EB 2 applicants. For China, EB 2 remains at January 1st, 2022. No movement this month. EB 3 category, skilled and professional workers. For most countries, except India, China, and the Philippines, EB 3 becomes current on the dates for filing chart. For India, EB 3 advances to January 15th, 2015, a 5-month gain. For China, EB 3 moves to January 1st, 2022. Family-based categories. The F2A category, spouses and children of lawful permanent residents, is current on the dates for filing chart. This is good news for families in this category. Now, here's the important context behind this movement. The State Department has been advancing these dates faster than usual, and there is a reason for that. Because the Trump administration has paused or restricted immigrant visa processing for nationals of about 75 countries, fewer visas are being used up by those applicants. That means more visa numbers are now available for people from other countries. However, and this is a warning, the State Department has said clearly that this forward movement may not continue. If demand increases, or if the administration changes its policies, some of these dates could go backward. That is called retrogression. So if you are eligible to file right now, based on these April dates, Immigration attorneys are strongly recommending that you file as soon as possible. Do not wait. So let's bring all three of these updates together and talk about what they mean for real people. If you have a pending asylum case with USCIS, check your country. If you are not from a travel ban country, your case may start moving again. This is the first good news for asylum seekers in months. If you are from a travel ban country, Nigeria, Somalia, Afghanistan, Haiti, Venezuela, and others, your case remains on hold. We do not know when that will change. Consult an attorney and make sure your documents and address are up to date with USCIS. If you are in ICE detention or worried about being detained, be aware that courts are now supporting the government's authority to hold you without bond in multiple states. Knowing your rights and having legal representation is more critical than ever. If you are waiting for a green card through employment, the April 2026 Visa Bulletin has good news. Many categories move forward. USCIS says you can use the dates for filing chart in April. Act quickly. Do not let this window close. And for everyone, remember, immigration law is complicated. Policies can change fast. Always work with a qualified, licensed immigration attorney who can look at your specific case. Do not rely on social media rumors or people who are not licensed attorneys. Your immigration case is too important for that. 1. DHS has lifted the asylum adjudication hold for thoroughly screened applicants from non-travel ban countries. If you are from a country not on the travel ban list, your asylum case at USCIS may start moving again. 2. Two federal appeals courts, the 5th and 8th Circuits, have ruled that certain detained immigrants have no right to a bond hearing. This affects states across the South, Midwest, and Great Plains. If you or a loved one is detained, get legal help immediately. 3. The April 2026 Visa Bulletin shows significant forward movement in employment-based categories. EB-2 and EB-3 are current for most countries. India EB-2 and EB-3 moved forward by several months. If you are eligible, file now. We will continue to monitor all of these developments and bring you updates as they happen. If you found this video helpful, please give it a thumbs up and share it with someone who needs this information. And if you haven't already, hit that subscribe button and turn on the notification bell so you never miss an update. Thank you for watching Immigration Radar USA. Subscribe for the latest U.S. immigration updates. Stay informed. Stay prepared. We'll see you in the next video.